morning, everyone, and thank you so much for joining us today to celebrate the World IP Day, which title is Intellectual Property Right, Small Medium Enterprise Taking Your Idea to Market. I'm Lorenzo Montanari, Executive Director of Property Right Alliance, a research and advocacy group based in Washington, D.C., in charge of promoting and defending IP and innovation around the world. First of all, let me thank you the PRA team, in premise Philip Thompson, IP and trade specialist, as well as the two fellow Krisa Kazakov and Georgina Agostini, and our associate Rowan Sadlowski for the great day-by-day work on IP, free trade, and innovation. PRA is in charge of publishing every year the International Property Right Index with Professor Sara Levi-Carsiente and the International Trade Barrier Index created by Philip Thompson. While today, for the first time, we will be launching the update version of the 2021 Trademark and Patent Index, co-authored by Krisa Kazakov and created by Professor Park from American University. Our international activity and advocacy efforts are possible thanks to an outstanding network of more than 120 think tanks covering more than 70 countries. Our appreciation goes to all our partners for their enduring effort to defend innovation, property rights all over the world. It is more than 1 year ago since the World Health Organization declared the COVID-19 outbreak a global pandemic, a health crisis that has seriously affected human life and global economy. In less than a year since the outbreak started, researchers, private sector, with in some cases partnership with the public sector, were able to discover valuable vaccine crucial to save life and with the final goal to defeat the COVID-19 pandemic. These results are facts that highlight the fundamental role played by intellectual property right in discovering vaccine and saving life, exactly the opposite message that some countries such as India and South Africa are pushing with their IP wave. It is simple like that. No IP, no vaccine, no life saved. Like every year, Property Right Alliance will present during this webinar an international coalition letter addressed to WIPO Director General Darren Tang to support IP and innovation, of course, to celebrate the World IP Day. We are very excited about this letter. This year, we were able to collect 101 signatures from 47 countries. Today, we have a great agenda lined up with great speakers. In particular, I want to thank WIPO Senior Director Philip Bachetol for his welcoming remark, and our special guest, Andrei Iancu, former Undersecretary of Commerce for Intellectual Property Rights and also former Director of USP Patent Office during the Trump administration. Before inviting Philip Bachetol, I'm delighted to leave the floor to Grover Norquist, President of Americans for Tax Reform, for his traditional remark for the World IP Day. Grover, the floor is yours.
Lorenzo, thank you very much. As every year, we're delighted to celebrate with the Property Rights Alliance and the pro-intellectual property movement, the World Intellectual Property Day, organized by the World Intellectual Property Organization. It is a good day to celebrate the power of intellectual property and what it does to improve people's lives. I also want to thank, as you mentioned, 101 supporters of the Property Rights Alliance coalition letter, sending just that message, and specifically to congratulate our Property Rights Alliance fellow Krisa Kazakov for updating the trademarks and the patent index created by Professor Walter Park of American University, something that's going to be very helpful in years to come. We just coming through a pandemic with a real lesson that property rights in intellectual property is not just good for the economy, it saves lives. And with that in mind, and the fact that the Property Rights Index finds an almost perfect correlation comparing property rights overall with the Global Biotech Innovation Index. Intellectual property rights prepares us to take on things like COVID. Lorenzo, back to you. What a year to talk about the benefits of intellectual property and the damage that would be done if some of the critics of intellectual property actually had their way.
Thank you, Grover. Thank you for your work and for your commitment. This is extremely important to remind everyone the important role by IP in saving life. I want to welcome now Philip Bachetol, WIPO Senior Director at the Patent Cooperation Treaty Department, for his welcoming remark.
Thank you, Lorenzo, and good morning from Geneva to you in Washington and elsewhere, and a very happy World IP Day. On behalf of WIPO, Director General Darren Tang and Deputy Director General Lisa Jurgensen in the patents and technology sector, thank you to the Property Rights Alliance for giving me the opportunity to say a few words at the opening of this policy webinar on the occasion of World IP Day. As I begin, I can perhaps just say a few words about WIPO and what is going on here. We have a new leadership, as you know, at WIPO, and many new ideas and initiatives. John Sandage, who many of you know, has been replaced by Lisa Jurgensen, former Executive Director of AIPLA and former Chief IP Counsel of ST Microelectronics. And DG Darren Tang, former head of the Singapore IP office, now dynamically leads the organization towards new horizons. Concerning some developments of WIPO services, let me just mention that international patent applications filed via the Patent Cooperation Treaty, the PCT, grew by 4% in 2020, while WIPO's international trademark system slightly dipped by 0.6% in 2020, but that was not unexpected given that trademarks tend to represent the introduction of new goods and services, both of which slowed as a result of the global pandemic. The demand for designs under the Hague system fell by 15% in 2020, and that's the first such decline since 2006, I must say. On the other hand, concerning the WIPO's Arbitration and Mediation Center, trademark owners in 2020 filed a record number of cases under the Uniform Domain Name Dispute Resolution Policy, and WIPO mediation arbitration cases more generally involving patents, trademarks, digital copyright, and other types of disputes involving technology grew by 24% in 2020. So we witness mixed results in our registration systems, but overall, in light of the pandemic, this is a positive outlook and outcome, especially since the PCT accounts for 75% of WIPO's total revenue. But let's come back to our theme for this year's World IP Day, which is IP and SMEs taking your ideas to market. At a time when the imperative of economic recovery is high, the 2021 theme shines a light on the critical role of SMEs in the economy and how they can use IP rights to build stronger, more competitive and more resilient businesses. And indeed, considering how the scale and the speed of technological development have increased, we all need to reflect on the role that innovation plays and how the IP system can contribute in driving global efforts to protect health, address environmental challenges, and support society in general. It is estimated that SMEs make up around 90% of the world's businesses, employ around 50% of the global workforce, and generate up to 40% of national income in many emerging economies. In a series of recent studies, the European Patent Office and the European Union Intellectual Property Office found that SMEs which had patents, registered designs, or trademarks were more likely than other firms to achieve high growth in turnover in subsequent years. The analysis showed that SMEs which own IPRs have a 68% higher revenue per employee than those that do not own IPRs at all. SMEs that own both patents and trademarks generate 75% more earnings, while those that have registered designs and trademarks have an estimated revenue premium of 84%. And SMEs that own a combination of patents, trademarks, and registered designs generate almost double the revenue per employee compared with companies that do not own any of the 3 IP rights. This all looks like really exciting evidence for tying IP rights to economic performance within the context of SMEs. However, the studies also identified that fewer than 9% of SMEs in Europe own any of the 3 types of IPRs, compared with almost 6 out of 10 large companies, highlighting both the significant potential among smaller firms and further exploiting IPRs and the challenge in awareness raising about the benefits of IPRs. WIPO believes we can only be successful in meaningfully support SMEs if we build a network of partners helping us to reach out to the many SMEs in the world, and we are therefore immensely grateful to organizations like yours for their great support. Let me, in closing, thank and congratulate the Property Rights Alliance for its World IP Day coalition letter and for its ongoing advocacy work relating to intellectual property. We at WIPO certainly have much in common with your organization in its goals of raising awareness of the importance of intellectual property rights, and we continue to look forward to working with you all. Thank you very much, and a happy World IP Day.
Thank you, Philippe, really for your kind word, for your leadership, and we're really looking forward to work with WIPO in the future and to celebrate every year the World IP Day. What you share, the data are very encouraging. I think that this year we should say that this is the year of IP, consider the role they are playing in discovering vaccine. But thank you again for your leadership, and really looking forward to work with WIPO in the future. Now, it is our great pleasure and honor to invite Andrea Iancu. He's a former Undersecretary of Commerce for Intellectual Property Rights and former Director of US Patent Office. He was nominated for both positions in 2017 by President Donald Trump, and he left office in January 2021. Mr. Iancu, the floor is yours. Thank you for your time and accepting our invitation.
Thank you, Lorenzo. Thank you for the kind introduction and for inviting me to be with you. Happy World IP Day, everyone. Congratulations to WIPO for every year putting on organizing a fabulous set of events. Congratulations to Darren Tang for your superb leadership of WIPO so far. I know this is your first IP Day as new Director General. Congratulations to Lisa Jurgensen as the new Deputy Director General for the patent sector, and everybody else at WIPO. And special congrats to the Property Rights Alliance for this program and for everything you do, including the World IP Coalition letter that others have talked about before. It's a great accomplishment to have so many signatories on such important issues. So the theme this year is small and mid-sized enterprises, SMEs. And let me start by telling you a story that is prototypical of IP and SMEs. In the mid-1990s, two engineers in the prime of their careers, working at big established engineering companies, thought that they would like to strike it on their own. They had some great ideas and wanted to see what they can do with them if they started their own company. So they left really good jobs, depleted their savings accounts, and started a new company. With great idea in hand, they also got some patents. The technology, the brand new technology for recording television digitally, or the modern digital video recorder, DVR. They called the company TiVo. TiVo, turns out, in retrospect, changed the way we watch television. A true disruptive technology. Their new device was a set-top box. You know, these boxes that sit next to or on top of the television set. But the issue was that the big cable and satellite companies also had set-top boxes that originally did not have any DVR recording technology. And instead, you had to hook up the good old VCRs. You might recall the blinking light. You could never figure out how to record things. But anyway, so the big satellite established companies and cable companies decided that they don't want to deal with the new upstart TiVo, and instead either ignored it and did not include DVR technology for their customers, or some of them, when pressed by their customers and they thought it was a good idea, decided to copy TiVo's technology. The good thing, as I've mentioned, is that TiVo had a series of patents, and TiVo decided to enforce their patents. TiVo, in the long run, got an injunction and royalties. Ultimately, TiVo got almost $2 billion in royalties for its patents. And as we now know, DVR technology is ubiquitous. Now I ask, what would new startup TiVo have done without patents? You see, the TiVo story is typical of SMEs. Patents and intellectual property is critical for these businesses. And it's certainly critical from an economics point of view. Philip mentioned, let me mention a statistic in the United States. In the United States, a startup's first patent application increases its employment growth over the next 5 years by almost 40%. And the the effect on sales is even larger. Also in the United States, SMEs create 2/3 of all new jobs. So you see, you put these things together, and we now understand how important IP is to SMEs and how important SMEs are to the economy, and therefore how important IP is to the overall health of the economy. But again, for small businesses to succeed, they need IP. In fact, IP is primarily meant for them. It is hard for SMEs to compete against established firms without intellectual property protection. It is hard to disrupt established businesses. SMEs have few other tools to compete to win other than their great ideas. They don't have size. They don't have vertical integration capabilities. They don't have economies of scale. So advocating for strong intellectual property rights really is advocating for small and medium enterprises, for startups, and for economic growth. In fact, if you want competition, if you want to prevent monopolistic behavior, if you want, then you want to strengthen intellectual property rights and give the little guy a shot at winning. The founding fathers in the United States really understood this. This is why the intellectual property clause is included in the Constitution itself. In fact, the word right is mentioned in the body of the Constitution, amendments aside. The word right is mentioned in the body of the Constitution only once, and that is in Article 1, Section 8, Clause 8, the Intellectual Property Clause, which gives Congress the right to establish laws to promote, quote, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. I want to point out something. The Constitution says that the government is to secure to the creators their exclusive right, not to grant or to create an exclusive right. It's to secure that right. The right already exists in the creators themselves. Let's compare that to the Declaration of Independence, which says, as we all know, quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among them are life, liberty, and the pursuit of happiness, and that to secure those rights, governments are instituted among men, deriving their just powers from the consent of the governed." The Declaration of Independence recognizes natural rights of life, liberty, pursuit of happiness, and government's role is to secure those rights. It's the same for the intellectual property that creators have. They have their rights, governments secure those rights. And once we understand that, we really understand what it means to have intellectual property rights and what the government can or cannot do with them after those rights have been secured. SMEs, as I've said, depend on those rights. They grow businesses based on those rights. They make investments based on those rights. And they need to be secure in those rights in order to be able to succeed. It's true of all companies, in fact, and all IP owners, but so much more for the little guy. Let me leave you with this thought. The impact of IP has on small and emerging businesses has been highlighted just last week in front of the Senate Judiciary IP Subcommittee chaired by Senator Leahy from Vermont. And one witness at this hearing last week, a young lady from Senator Leahy's state in Vermont, Her name is Georgia Grace Edwards. She testified to the importance of IP. Miss Edwards, by the way, is just 25 years old. But she started her own company that specializes in women's outdoor clothing called SheFly. She testified, and I quote, "My ability to protect my ideas was crucial to my ability to scale and succeed. Patenting is extremely central to our business model. In our country's vibrant and highly competitive startup ecosystem, patents make or break an entrepreneur's ability to signal legitimacy in a market, gain new customers, establish additional revenue streams through licensing, and achieve a favorable valuation with investors. More importantly, our patents are what will allow us to bring our technology to people in all different sectors." Close quote. How right she is. These are the folks we need to encourage, because with inventors and entrepreneurs like Miss Edwards and like the TiVo founders and so many more, both in the United States and around the world, our future is bright indeed. Happy World IP Day, and thanks for the invitation to be with you.
Thank you so much for your kind word and regarding our lecture, and also remind everyone that property right, like IP, are natural right. In fact, if we see the number between European Union and United States, almost 150 million jobs are related to IP industry. These are clear number in terms of what type of role IP are playing in our economy. But thank you again for your leadership, and in also during the Trump administration fighting any type of IP theft. We have a couple of questions. The first question is from a journalist in Italy regarding what is your position, your opinion about the IP Wave proposal led by South Africa and India regarding our override IP for the vaccine.
I think that the waiver proposal is a dangerous proposal for many reasons. One, is dangerous to innovation. If we waive IP rights that have been already secured, it really puts in danger the future innovations that are going to be critically important for the next potential health crisis or pandemic around the world. Inventors and investors need to feel secure in their rights in order to make all those investments that have led to what we have seen, a remarkably fast deployment of multiple vaccines around the world. But more importantly, Lorenzo, the waiver right now would pose an immediate danger to the widespread distribution of quality vaccines. Number one, we know that because of intellectual property rights, the innovative companies have already entered into hundreds of license agreements around the world. The big companies and the small companies alike are collaborating both here in the United States and all over the world. For example, AstraZeneca has a very significant deal with the Serum Institute of India, through which India is going to make more than 1 billion doses of vaccines, second only to the United States. Pfizer is collaborating with Novartis and others. Not to mention, of course, BioNTech, small company from Germany, collaborating with Pfizer in the first place. If you remove IP, companies will likely retreat into their trade secret shells and be less willing to engage in this worldwide collaboration. And second, if you waive IP rights and we allow a free-for-all manufacturing of these very complex technologies, because we have to remember, these are complex technologies to make, not anyone can make them. If we waive IP rights and we take the original manufacturers out of the picture and anyone around the world can just make them at will, how are we going to control the quality of these vaccines that go into people's arms? How are we going to control for the potential fake vaccines? We have seen just last week that fake counterfeit Pfizer vaccines were discovered in a couple of countries, I believe Poland and Mexico. If we allow the broad-based manufacture with no intellectual property controls, how do we control for those things? And finally, Lorenzo, the system right now has worked incredibly well. Again, we got to multiple vaccines in less than a year. Second, we already have deployed over 1 billion shots around the world. By the end of May, there's going to be 2 billion. And by the end of this calendar year, 2021, about 9 to 10 billion shots will be administered around the world, enough to vaccinate the entire adult population of the world. The system is working. Let it work. Remove trade and other restrictions that are unnatural, but leave IP alone. IP is the part of the solution, not part of the problem. The system is working. Let it work for its intended purposes.
Thank you so much. Another question we receive is regarding IP cybersecurity, and also what type of policy the new administration in the United States, but all administration in Europe should face to contrast IP theft, mainly from China.
Well, IP theft is a scourge on the world trade system. Hundreds of billions of dollars annually diverted, according to the OECD, towards fakes, and more than 85% or so, according again to the OECD, more than 85% or so of counterfeit products come from China and its territories. So governments need to work together around the world to, in a collaborative fashion, to prevent this theft of IP. And the fact is that people need to realize that this is not just an economic issue. It certainly is an economic issue. As I said, hundreds of billions of dollars a year from legitimate companies are being diverted. But more importantly, these are health and national security issues, right? If we allow the introduction of counterfeit vaccines, for example, counterfeit drugs, even counterfeit toys, people's lives are in danger. And in fact, there's lots of documented data that many deaths have been caused by counterfeit products. Not only that, revenues from counterfeit products are being used for other illegitimate international businesses, such as drug and human trafficking and international terrorism. People need to make the link between what IP protection means and their day-to-day lives, both in a positive way, because we know how much good intellectual property does through innovation and economic growth, but also people need to be aware that laxing intellectual property laws also cause a lot of harm, both economic, therefore their day-to-day livelihoods, as well as health and safety.
Thank you again.
People need to make that link.
Thank you again, Mr. Yanko, for your leadership, for your great presentation and comment. We're really looking forward to have you again in our event. And I know you're a busy day today, so thank you again for your time and for your leadership.
Thank you, Lorenzo, and a pleasure and honor to be with all of you.
Thank you so much. Now we move to the second part of our policy webinar. We'll invite Philip Thompson, IP trade specialist for PRA, to present our international coalition letter to celebrate the World IP Day. Thank you, Philip.
Thank you so much, Lorenzo, and thank you to our excellent speakers. I think I'll be repeating some of the numbers already presented by Philippe and Andre, but they are very powerful statements in and of themselves. So this year, our coalition letter is signed by 101 groups from 47 countries. For the past 5 years, every year, we've added more members to our coalition letter. Back in 2017, we had only 61. So hopefully that means around the world, we're helping to increase appreciation for intellectual property rights. And we're making progress on pushing back on a dangerous narrative that says if there's only weaker IP protection, somehow there would be more inventions, more artistic works, more designs, and everything would be much cheaper. Of course, the opposite is true. The message in the letter is that IP rights, especially for startups and small and medium enterprises, are vital. Research shows that firms that receive patents experience 55% higher employment growth, 80% 80% higher sales growth over 5 years, and these patents also attract funding from venture capitalists, banks, public investors as well. Yet more work needs to be done to ensure SMEs have an IP strategy. In the EU, for instance, only 9% of firms are using IPRs as part of their business strategy, yet those firms generate revenues that are 68% greater per employee than firms without IPR protections as part of their portfolio. This year, more than ever, we should be celebrating the role of IP in expanding the frontiers and building the future. The guaranteed period of exclusivity offered by patents allow long-term investments in areas where market outcome is not always guaranteed. For instance, the COVID-19 vaccines, Pfizer and Moderna, have been developed from these small biotech companies that were researching mRNA technology for the last 2 decades without ever developing a drug candidate that was approved in the market. All they had were patents and research showing incremental improvements that allowed them to raise funding and create partnerships. This year, we expect similar incremental improvements in technologies such as recycling, personalized medicine, solar panels, and these are all only due to patents and IP protections that will culminate in making a future that is brighter, safer, and cleaner. Yet despite this clear evidence, there is movement, it was already mentioned earlier, the waiver at the WTO to remove IP protections on products used to fight COVID-19. Even though there's no evidence that IPR protections stand in the way of producing more vaccines, PPE, or medical tools. At the same time, other tools do exist in the global trading system that would deliver tangible results. For instance, removing export barriers to these items. The letter states that the TRIPS agreement is the most comprehensive multilateral agreement on IP and the most effective instrument for ensuring that governments take steps to protect IP, and that it would be a grave mistake to waive the minimum protections secured by TRIPS. Again, this message isn't coming just from organizations in the US. This is 101 groups from 47 countries. It's hard to imagine that these breakthroughs would be there if these waivers were made for other health crises, like SARS, Zika virus, or Ebola. In addition, through the pandemic, there has been a surge in counterfeit, substandard, falsified medical products, as Iancu mentioned earlier, including for vaccines and PPE equipment. The letter warrants waiving IP rights would make it even more difficult to police these dangerous products. Lastly, regions that have cultivated strong appreciation for IP rights, such as North America, Western Europe, have experienced abundant growth. In the United States, they add 6.6 trillion in value added to GDP. They support 45.5 million jobs and pay a wage premium 42% greater than similarly skilled employees in other industries. Likewise, in the EU, IP-intensive industries employ 30% of the workforce and are responsible for 45% of GDP, and they earn a wage premium 20% greater. It's no surprise that we find in the 2020 International Property Rights Index, copyright protections in the EU and North America are 30% greater than the rest of the world. In fact, in the 21 countries with the strongest protections, they are home to only 15% of the world's population, but they produce 49% of the world's GDP. These regions with robust IP enforcement have already been growing faster than others due to their IP-intensive sectors. When the pandemic hit, it accelerated adoption of digital technologies, and these same regions were simply better equipped to make that transition easier. And when it comes to the economic recovery from COVID-19, these same regions are in a better position to take off. So there is a crisis when it comes to global intellectual property rights, and it's that countries need to do much more to close this IP protection gap. So the solution is clear, and the letter asks 3 things of WIPO and the WTO: to assist countries in creating comprehensive approaches to IP, to educate policymakers on the benefits of intellectual property, and promote cooperation at the WTO, the WHO, and other multilateral fora. So thank you so much to Lorenzo, to our speakers, and to WIPO and our 101 signers of the IP Day Coalition letter. Thank you, Lorenzo.
Thank you, Philip, for the presentation. It actually is really exciting that this year 101 think tanks all over the world, they are sign this joint agreement statement on Pro IP. I think the IP movement is growing every year. And of course, April 26th, the World IP Day is always a great opportunity to get together and to raise the awareness of how IP are important for innovation and for our life as well. So with a great pleasure, I want to introduce now Professor Walter Park from American University and our PRA fellow, Krzysia Kazakov, because for the first time ever, Property Right Alliance in partnership with Professor Park, American University, we were able to update the trademark and the patent index that Professor Park created years ago. It's a great pleasure and honor for us, and this is today is a great opportunity to officially launch the new update version. And of course, the index will be available today in our website, and also we will be happy to share the data they are behind our index. I want to invite Professor Park and Krzysia Kazakov to join us today.
Morning.
Morning.
Or whichever time zone people are in. So, okay, I'll just begin with an overview. This index that we are going to discuss measures the strength of patent and trademark protection around the world and over time. Well, what they measure is the strength of patent and trademark protection, not necessarily the quality or the optimality of protection, but basically just what are the policies and regulations and laws that were either passed or are in existence that contribute to the strength of protection. And again, the goal of the index is not just to keep track of those legal and regulatory changes, but also for researchers to use the index to analyze the determinants of protection. Why do some governments or policymakers offer stronger protection than others? And also to study the impact of protection. So how do patent and trademark laws and regulations contribute to innovation, technology transfer, create new businesses or expand businesses? With this index, you can do before and after analyses, right? You can determine, at what point where certain policy shifts took place, and then do a good before and after analyses. And so essentially this index, we have to be careful what it contains and doesn't contain. What it mainly contains are those selective items that could help us look at variations in strength across countries. So some countries all provide the same thing. In that case, it doesn't contribute to any variation. So we focus on things like what kinds of protection countries cover, what are some of the enforcement mechanisms they have, what is the duration of protection, are they members of international agreements that protect IP, and finally, are there any provisions that take away rights, for example, compulsory licensing or working requirements, forfeiture. What it doesn't include are measures of piracy or somebody mentioned intellectual property theft, counterfeit. These are actions that take place. We don't, the indexes don't measure those. The index focuses on statutory and case laws. So that's basically the blueprint of the index, to look at these different components. What we did was unweight them and just add them up to give us an overall score, but other researchers are welcome to adjust the weights as they see fit. That's overall the blueprint. I think the hard work was done by Krzysia, so I'll turn the floor over to her to describe, and I'll be available to answer any questions about the index.
Thank you, Dr. Park. Thank you, Lorenzo. It's a pleasure to welcome everyone in our webinar for the celebrating the World IP Day and presenting the International Trademark and Patent Index 2021. By the end of this presentation, you will be able to know which are the countries with the highest scores in the trademark and patent protection. So let's begin with an overview of the methodology that we follow. So the International Trademark Index and the Patent Index offer a tool for measuring the protection of trademarks and patents, or in other words, the strength. The Trademark Index covers legislations from 139 countries around the world, while the Patent Index covers patent legislations from 122 countries. The selection was determined only by the availability of sufficient data. And we would like to point out that the acquisition of IP is one of the primary tools for incentivizing creators in a modern economy. So, okay. Great. So let's move to the methodology more in details. As I said before, we measure the strength of the IP rights. The legal feature selected, as Dr. Park said, has to do more with the maximal variability across the countries. We do not measure the economic development. There may be some important determinants of development, but they are not themselves the indicators for ranking the countries. As an overview, the trademark has 4 clusters, which is about 21 components. Each of the clusters contains a combination of variables, and then the final score is the average of those 4 clusters. While the patent index follows the same methodology, more or less, but now we have about 6 separate clusters, and the final score is the unweighted sum of those. The grading scale of both indices is between 0 to 1. 1 is the highest value for each cluster, and 0 is the lowest value. Of course, all the variables for the indices, all the components that we use, all those 41, are extracted from all the relevant laws as they were published in WIPO Journal Intellectual Property between 1960, when we started updating the score sheet back with the methodology of Dr. Park, and 2021, that now we have the update. So after the methodology, let's say how we can break the structure to have some more details about our cluster. First of all, we have the coverage, which is the range of the trademarks or the patents, because coverage is a cluster that we could find in both indices, that are allowed to be registered in a country. After we have the membership in treaties, we all know that the more items that are protected in a law, the better the law is for the right holder. Either he is holding a trademark or he is holding a patent. Then we have the restrictions, which include licensing requirements, assignment conditions, linking requirements, or even conditions of use. And finally, we add trademark applications or patent applications, respectively, for the patent index. But here we add the non-resident application. Why is that? Because we know that there are many resident applications as well. So the non-resident applications are of greater value because they capture a legal motive for seeking protection in a country, not only because of its market size or because of the attractiveness of a destination, but one of the reasons that someone wants to file a trademark on a patent in a country is because of the efficient or not IP system. So this is the last component in both indices added that we thought that we will give a more in-market side to the results. So in a nutshell, United States lead both of the indexes, both the trademark and the patent index. As a result, this shows for the states that they provide the tools necessary to prevent IP infringement. Canada is ranking secondly in the International Patent Index with a point of 4.88, while China ranks second in the Trademark Index with a point 0.8625. The second position also demonstrates a commitment committed and successful effort to safeguard and enforce patents. On the other end, we have Mauritania and Togo, which could be found in the bottom rankings of the trademark index. And then we have Somalia and Myanmar, which have the lowest scores in the patent index. We know that the weak protection of IP could pose a significant barrier to international technology licensing and could reduce direct investment. Let me show you also, I'm sorry for that. Okay, now it works, perfect. So we have the 10 countries in each of the indices that have the highest scores. As I said before, you can see United States, you could see China, Austria. Austria has a very effective legal system for both trademark and patent protection. United Kingdom, Hungary, France, Sweden, Germany, and Portugal. While for the patents, you can see Chile, Norway, Australia, Germany, China, Austria, and Spain. Just the final slide. Okay, great. So, I'm sorry for that. I need the slide before that. Maybe it's stuck. Okay, maybe it's stuck. It's okay. I would like just to conclude that we know that IP protection is the most important part for a free market and for a stable economy. I think that during the pandemic crisis, everyone pointed out that a real balance between the licensing and the protection of IP is necessary so as to have a solution for the pandemic. Okay, now we have the final slide. Thank you. IP encourages everyone to have creativity and innovation in his everyday life. And I would be glad to hear your comments. Thank you for your attention. I would like to especially thank Lorenzo and Dr. Walter Park for their commitment to the protection of IP environment. Thank you.
Thank you, Krista, for the great work, and thank you, Professor Park, for this partnership. I think, and I really hope that this index can be a new policy tool we can be used by anyone, policymaker, policy activist, anyone that are working in the field of patent and trademark. Again, it will be available in our website today, and happy to share the data as we deal with the trade barrier and the international property right index as well. So we will collect eventually the question at the end. I want to invite now Seth Hayes, is a chief representative for Asia Pacific for the International Trademark Association. And Seth, thank you so much for joining us. It's the first time that we have someone from International Trademark Association. It's a great organization fighting all over the world for the protection of trademark, and it's a great pleasure to have you here with us. I know that is also for you is a busy day for the World IP Day, so we double appreciate your time. Thank you.
Yeah, absolutely. Thank you very much, Lorenzo. Good morning, afternoon, evening. It's evening here in Singapore, actually. World IP Day is quickly coming to an end here. So it really is an honor today to share the video screen with such respected panelists and professionals in the intellectual property community. I'd really like to thank the Property Rights Alliance and congratulate you on the publication of the 2021 Trademark and Patent Index. Fantastic information. I know that I'll certainly be reading it very closely. Philip, if we could start with the slide before that one. I'd like to briefly share two regulatory trends to watch in the world of trademarks. I'm going to call this the trademark squeeze. That is between privacy regulations on one hand and brand restrictions on the other. These two trends are squeezing the ability of trademark owners to use their marks as intended and to prevent unauthorized use of their marks. Trademarks are really between a rock and a hard place. So how do we get out? Hopefully I'll be able to give you some directions out of this rock and hard place at the end of the presentation. So let's talk a little bit about privacy. With the EU's adoption of the privacy regulation, GDPR, of course, we all saw numerous emails in our inboxes and updates to websites on how our personal data was being handled. One of the unintended consequences of the GDPR affected the ability of brand owners to police their marks online. Namely, ICANN, that's the Internet Corporation for Assigned Names and Numbers, the organization that manages the domain name system, blacked out the identifying information of website owners contained in the WHOIS database. Now, this information was important, was an important investigatory tool for brand owners searching for infringers online. Next slide. What we have seen since is an increase in domain system abuse, DNS abuse, which includes phishing, pharming, malware, botnets, spam. Much of this abuse exploits internet users' trust in the brands to get them to click on spam and visit fake websites. Trust is the Trojan horse, and brands represent trust. Actually, on this slide here, I actually took a screenshot of a note that my bank gave me off to the right-hand side of the slide. It said, watch out for spam and fraud with their DBS logo on it. So it's everywhere. Next slide, Philip. So there are a number of recent reports outlining the magnitude of the problem. I'm happy to share here some research papers from governments and consultancies here. Next. This past year, actually, I'd like to state that the pharmaceutical industries has been severely impacted. In particular, fewer and fewer domain name registries are enforcing their policies against counterfeit medicine sellers. This is information from the Pharmaceutical Security Institute, PSI. Now, let me talk about the other trend we need to watch out for in the trademark world. So next slide. That is brand restrictions. I think many of us are familiar with brand restrictions in the tobacco industry in places like the UK, Australia. They've actually removed the trademarks from the packaging of tobacco products with the public health goal of trying to get people to maybe be less attracted to the packaging and smoke less. But it's not only contained to the tobacco industry. Other industries are being affected across the world in every corner of the globe. So on the slide here, I actually have a case example from Chile. In Chile, they're trying to combat child obesity, so they thought it would be a good idea to remove trademarked characters from the cereal boxes here. Actually, you can see that removing these characters really reduces the distinctiveness of the packaging, and creating distinctiveness between products is one of trademark's core goals. So next slide. And the next one as well. So this example here is from South Africa. So we actually see the removal of images of babies from the packaging of baby food and formula. Now, whether or not and actually right here is a baby animal, a little baby bear, which is removed. And these can be trademarked images. And the goal here was apparently to induce mothers not to purchase these products. And I believe there was a breastfeeding goal, and so they didn't want people to be buying infant formula here. Not sure exactly what the link is between images of babies and inducing people who need to buy infant formula, but that's the rationale. So next slide. So the proposals really just keep coming in. And you can see here these proposed graphic health warnings for boxes of pizza, boxes of juice, really crowd out the trademarks and the ability of the trademark to function. So you see, this is a Canadian proposal, but it doesn't stop there, and it doesn't actually stop at public health. So let me show you the next picture. In fact, we've just heard that there's a country out there who is going to plain package football or soccer, depends on your country. Next slide. And they're not doing this for public health, but really for social order. So, well, I hate to break it to you, but if anybody here believed that, that's a little bit of fake news. I actually doctored those images, but it's not entirely outside the realm of possibility. And if you actually believed me for 1 second, I think we have a problem. And just to give you an example, in Hungary, there was actually a call to remove red stars from all packaging of all products. This is for political reasons because of the previous communist era. But that would have meant that Heineken would have lost its red star, or that San Pellegrino would have lost its red star on its packaging. I remember once reading an article from Australia calling for the plain packaging of financial services, I guess in order to deter consumers from getting into high interest loans. So let's talk a little bit about what we can do to fight, to protect brand owners' abilities to protect their rights online because of these privacy regulations, which are preventing brand owners from having access to that WHOIS data. So right here, we need to explicitly recognize that online IP infringement is a cybersecurity threat. I think that's the most important one. Really meaningful voluntary practices need to supplement all of the contractual obligations that registrars and registries have with ICANN, and really that the public has with the internet in terms of trust. So next slide and final slide. What do we do about brand restrictions? INTA, we have our board resolution here. I really want to call out part 2 here down at the bottom. It says governments really should use less drastic alternatives to address health and safety goals, such as public health education campaigns. And actually, I'd like to point out that there is research that indicates plain packaging does not reduce consumption. Actually, it increases consumption. There's a great article in Nature last year, a couple of years ago. There was some excellent research about how plain packaging actually induces men to eat more potato chips. So again, I think to use the terms from TRIPS, trademarks really are being unjustifiably encumbered by these brand restrictions. And with those suggestions, I'll end my presentation. And certainly if you have any questions about any of this, I'm more than happy to reach out to you in the future and answer any questions. So thank you very much, Lorenzo. Back to you.
Thank you, Seth, for your presentation, and also for remind everyone also the problem of plain packaging in any sector, from pharmaceutical or counterfeit issue in pharmaceutical or plain packaging for food. Anyway, this is really a huge violation of IP and trademark, and we've been fighting a lot as a Property Right Alliance with our partners. So I really thank you as a reminder, because something extremely important. I think we will have time for a question later. We are running a little bit out of time, but I want to also invite now for a short presentation Professor Maria Vázquez. She's the director of a law department of the University of San Andres in Argentina, and she's also the director of the Master in Intellectual Property Right in partnership with WIPO. Maria, thank you so much for joining us today to celebrate the World IP Day.
Thank you so much, Lorenzo, and many, many thanks to the Property Rights Alliance as well. It is really an honor to share this panel with my distinguished colleagues. And I thank you very much for the invitation. I was quite fascinated actually to listen to Philippe from WIPO, who, as you say, is our partner in our joint master program here in the University of San Andres. And as well as listen to Andre and all of the speakers today. We here in our Center for IP and Innovation are also passionate defenders of IP as really an accelerator, as an enabler of ecosystems of innovation, and which we so need here in our region in Latin America. So yes, as Lorenzo introduced, besides being the dean of the law school here at our university, I have the honor to sort of lead our Center of IP and Innovation in this direction. And what we find in our center, we have, of course, been through now 5 years of our joint master program with WIPO, and we have graduates from all over our region. In fact, over 15 countries, from different disciplines as well, which is also interesting. The fact that we are not all attorneys, but are in fact investigators and industry specialists and professionals, and also authorities from the public sector in a specialist in engineering with expertise in biology, in biotechnology, in chemistry, as well, of course, as in pharmaceuticals and in law. And we have actually formed a real regional network of IP scholars and investigators and professionals. And it is our consensus today in our center that what is missing in our region in order to enable innovation. Well, we see year after year in the Global Innovation Index that even though many of our countries, Chile, Mexico, Brazil, Argentina, perform extremely well in areas of human capital and research and the quality of our universities and the presence of R&D companies in SMEs and startups in information and communication technologies, yet our rankings in the GII have not significantly improved to other regions in recent years. There is no country in Latin America, or in the Caribbean for that matter, that currently shows any innovation outperformance relative to its level of development, correct? So this often makes us in our center of studies question, why is it? What is it that we have not yet been able to transfer? Why have we not been able to translate our human capital, our universities, our research into innovation, into more innovation in our region? Well, and what we have come to the conclusion that really what we are needing today is more capacity building and advocacy in IP. There is, on the one hand, a lack of access to knowledge about IP, which is why we dedicate our efforts to this so much. And also there is perhaps a mistrust of IP, this view of IP as a barrier, as an obstacle, rather than as an enabler, as an accelerator, as part of a system, correct? And perhaps it is because of this that our research at our universities is, yes, curiosity-driven, academically driven, but yet there is, as of yet, no evidence that we can actually make that jump into the commercialization of our R&D, right? Something that is useful for our startups, for our SMEs, something that can promote innovation and development and economic growth, correct? So what we see today is that there is a consensus among our scholars that we need a paradigm shift that is changing the paradigm of intellectual property in Latin America, changing and switching from this idea of IP as a barrier to this idea of IP as part of a system which permits technology transfer. So I thought I would tell you, as I have a brief little window here, but I thought I would perhaps mention an investigation that I find extraordinarily interesting, done by one of our colleagues at another university here at Universidad Nacional de Quilmes, Darío Kodner. I mention it because I truly think that it is eye-opening. The investigation is called Blind Technology Transfer Process from Argentina. And in fact, what they have noticed is that Argentina has become, more than just a producer of exporting agricultural goods. It has, in fact, become more and more a producer of increasingly valuable scientific information. And this scientific investigation can have high impact in all over the world, really, and it has been published all over the world. And they have, in fact, in this investigation, identified how there has been a flow of information, which they call the blind technology transfer, a flow of information towards the development of technologies in other countries. So what they are saying is basically, as our scientists are not patenting much of the investigation that has or the results of investigation in our universities, they have in fact flowed into patents in other countries, right? Into flowing towards foreign technologies within 2 years of their publication in articles. So really what we see is that this has become, a ground for a bit of debate into why is it that our scientists are not patenting, and what are they missing out on by not patenting? So this is part of the work that we are actually working with today in our Center of Studies, sort of saying this mistrust of patents, this idea of patents as a barrier, this is not helping our innovation. We, in fact, need to patent our investigations. We, in fact, need to then enable that these patents and RIP can actually enable us into being part of an international technology transfer process. We truly believe that defending IP, defending the protection of IP, a robust protection for IP, and defending, this advocacy for capacity building in IP will truly change the paradigm in our part of the world and will enable much of our potential, our human capital, our investigations in universities, will in fact be the enabler for more production, innovation, development, and economic growth. This is what we think. And I thank you, Lorenzo, for giving me this moment to speak about what we are doing and a little bit about the Latin American context. Thank you.
Thank you so much, Maria, for your leadership in Argentina. And I think it's great to have a special master dedicated on IP in partnership with WIPO. It's a perfect way to build up new leaders in protecting IP and patent in Argentina, in the region. The last speaker, last but not least, is Martin van Staden. Is a member of the Rule of Law Board of Advisor of the Free Market Foundation. Is our partner in South Africa. Martin, thank you so much for supporting the letter. And it would be nice to have a quick update of what's going on in South Africa.
Thanks, Lorenzo. Thank you for allowing me this opportunity to speak. I am going to be very brief, and unfortunately, I hope not too superficial on the matter, but unfortunately, in South Africa, we are facing a government that is attacking property rights on all fronts. But in this particular context, many of you might be aware that South Africa, joined specifically by India, has called for the World Trade Organization to waive intellectual property rights related to COVID-19 and its associated vaccines, medicines, and counter technologies. This is apparently in the name of equitable access for poorer countries to those technologies and medicines. However, one cannot help but be struck by the hypocrisy or the superficialness of it all, because South Africa's problem is not IP and protection for IP products, but simply incompetent governance. It took South Africa's government far longer to acquire a vaccine for South Africa, while other African states like Rwanda did just that. By the end of March of this year, for example, South Africa only achieved about 25% of its vaccination target for that month. When we did acquire the first vaccines, we imported a large batch of AstraZeneca that was on the verge of expiring. And while this vaccine was still serviceable, South Africa decided to sell that to other African states rather than administer it to vulnerable people. And from there, sheer incompetence and slowness set in as government monopolizes the vaccination process, and very few people are being vaccinated. So while vaccine manufacturers were producing doses and signing deals all around the world late last year, the South African government stood silently by and waited until March of this year before taking any real steps. There are even sub-national governments in South Africa, as well as private medical groups that have the capacity and the willingness to roll out a massive vaccine drive. But the incompetence showed by the national government stands in the way of this. And unfortunately, international vaccine manufacturers seem quite keen to deal mostly and specifically with national government. Sometimes days go by without anyone receiving a vaccine, while the government has many doses of vaccines. So the South African government is going to the WTO and to other international forums saying that rich countries or wealthier countries are bullying Africa and the third world by not by having IP rights, which is nonsense. South Africa is only falling behind because of its own incompetence, and it has no one else to blame but itself. It actually shouldn't be dragging the rest of Africa in with it, because there some progress is being made. So we also cannot regard South Africa's demands for the IP waiver from the WTO in isolation. The government has been on what might be regarded as an anti-intellectual property rights crusade for various years. And this too should be seen in the context of a far broader anti-property rights crusade by government and its close allies. The most egregious example of this is the proposed Copyright Amendment Bill, which has been passed by both houses of parliament and now awaits the president's signature. So I am no IP law expert, so I will rely on another's description of this intervention to tell the story. And this expert is Professor Sadullah Karjekar, who is a professor in intellectual property law in South Africa, perhaps the foremost authority. And he explains that South Africa has up to now subscribed to the fair dealing system, whereby our law allows a closed list of exceptions to copyright protections. However, as Karjekar explains, the Copyright Amendment Bill will also, on top of fair dealing, introduce the well-known American system of fair use, which is not a closed list, but rather a open list of factors that a court can take into account when deciding whether copyright infringement has taken place or not. And the bill refers to both fair use and fair dealing quite liberally throughout. And the impression is that government is carving out such a spectrum of exceptions that the exception might be becoming the rule, rather than the protection of IP being the rule. Karjekar further worries that the bill will allow government to appropriate IP rights in the name of making educational materials available without compensating the authors of that material. An example is that academic journal articles must become open access within 12 months after they have been published, which threatens the academic publishing industry, and that, by extension, threatens peer review and the academic integrity of the academic process. And Professor Karjekar rightly asks, why would anyone really write educational material in or for a South African audience ever again? What I do know for a fact, however, is that the government followed a very flawed public participation process in its drive to bring this bill into law. It ignored the expert testimony that explained all of these illogicalities, like having both fair use and fair dealing provisions in the law. And it also ignored the very real possibility that if the bill becomes law, South Africa might no longer benefit from the United States' generalized system of preferences. And that could cost South Africa up to $2 billion US in export revenue, which is something that South Africa needs now in the time of pandemic, and this is really threatened by the Copyright Amendment Bill. So, in conclusion, the South African government has shown itself to be extremely hostile to the very idea of intellectual property and private property in general. But the world, and particularly the WTO, should not allow for such a bad actor to dictate the agenda. And I say this as a South African, a patriotic South African, that our government is a bad actor in this regard. It simply does not listen to level-headed South Africans who have been saying that this is the wrong path to embark on. we have to remember the precedent that an IP waiver for COVID-19 products would set. Profit remains the best and I would say the most effective motivator of innovation and the finding of solutions for any kind of social ill. This is not a problem. Many people think that profit is evil, but profit is human. It sets a precedent. If we set the precedent today and say we are banning IP rights for COVID-19, even temporarily, simply because it is an emergency, imagine what that will do to future innovation when humanity is confronted by another emergency, another pandemic that needs quick vaccine development. Innovators will know that whatever they do, they will be punished by governments thereafter, because there will be another so-called emergency IP ban. So properly conceived IP rights and really property rights in general are exceedingly important and must be protected from passing and temporary political passions like that is gripping South Africa at this stage. I would really recommend international players and the international community not to let South Africa and the select few other states represent such a serious threat to that protection. And in that regard, to a large extent, South Africa should really be ignored or at least corrected on this ill-conceived quest for this IP waiver, but also the domestic copyright legislation that South Africa is considering. It would be very helpful if other countries' diplomatic missions would put some pressure on the South African government to reconsider. And I think to an extent that has happened. The president has not signed the copyright amendment bill into law yet, and there is a chance that he might not ever do so. Here's hoping, and to the extent that the international community has put pressure on South Africa, thank you, and please keep it up. Thank you, Lorenzo.
Thank you, Martin. Really, count on us. Anything we can do with the pro-property right movement to help South Africa. We were there a few years ago to present the last edition of the International Property Right Index with Sally Levi-Calsiente. So we are perfectly aware what's going on, and this could be a very bad policy that can be unfortunately easily replicated in other countries in the world, but also in Africa, without talking about the EWC policy that is very detrimental for the economy. Thank you again. I think we have a couple of questions now for Maria and for Seth. What will help policymakers and academics to see IP as an asset rather than barrier to economic prosperity? Maria and Seth.
Thank you, Lorenzo. Could you possibly just repeat it? There's a part that I missed because of my connection.
Absolutely. What will help a policymaker and academics to see IP as an asset rather than a barrier to economic prosperity?
Okay, good question. Very good question. It's something that we often discuss. And I think much has to do with research, and much of what Property Rights Alliance does, this advocacy, we often try to explain in data what is happening, what has happened in other countries, and what we need to have happen here in Argentina, specifically with regards to economics principally, but also with regards to what has happened with lack of IP. What happens when we see IP as a barrier? There is really no evidence as of yet, and this is in particular with what we're discussing today here. I have seen no evidence, and being from Argentina, I'm talking now about the vaccines and the IP waivers, for example. What I find, and I'm speaking from Argentina, and with utmost respect for those trying to find a solution. I'm in a place where there is very limited access to vaccines, as in many developing countries. But we have yet to see any evidence from experts, especially experts in the production process of the vaccine, who say that IP is an obstacle. Yes, what I find that would be most useful is useful data research and this sort of policy research that one can give. Yes.
I don't know if Seth want to also answer this question. Otherwise, we move to another question for Krisia. If you can explain a little bit more the protection of IP in the US and China, and how the patent index can help to answer this question.
Thank you, Lorenzo. So IP protection and innovation are driven by multiple factors. US has an efficient and flexible IP system. Those has been shown not only from the institutional components, but also from the IP filings that they have, which are on the top of the list. Sometimes in China, we can see some IP trials that are faster than in the States. There is a problem, though, with the force in some foreigners to give and to move forward with giving the technology to the state under some circumstances. And that was the problem that we saw. And for this reason, the flexibility and the more efficiency, if I could say, from the states was the component that gave them the first position in both indices. There are some slight differences both in the IP fillings, that's the bottom line, and some in the institutional one that I think that they will be covered in the following years, perhaps.
And also, thank you. And also we have a question for Seth Hayes from Sari Levy. How to change the negative image of trademark and to show the virtuous cycle they promote it? What should we do also from the think tank point of view?
Yeah, I certainly agree with Maria's assessment that we really need to start with basic research. And so, for example, INTA, we put together really good pieces of research based on research that the US and EU had done about IP-intensive industries and the economic contribution that they have to their countries and blocks. So INTA did some research in Latin America. We studied 5 countries in Latin America. What was the value of IP to those countries? We did the same in Southeast Asia. So really targeting countries that are not developed countries, that are emerging countries, that really need to, that do have this somewhat negative or anti-IP sentiment. I would say that's one area where policy folks like us can work on. But I think we shouldn't neglect the public affairs piece, which is getting people to think about, at least in the area of trademarks, what is the value of brands to you? So I think really a public campaign about raising awareness on the value of trademarks, for example, or brands is important. Making sure that those are part of school curriculum, making sure that business schools pay attention to it, not just relegate IP to the law schools.
Thank you, Seth. Thank you, everyone. I really want to thank all the speakers and our great partner all over the world for their enduring support of promoting IP innovation. We are getting at the end of our webinar, and of course, thank to the public for attending this webinar. In conclusion, after all this wonderful presentation, we have to point out a very clear message. IP protection, build value, and growth for small businesses. We need to contrast the IP wave proposal led by South Africa and India, plus 100 developing countries. There is no evidence that overriding IP will contribute in a better distribution of vaccine. The TRIPS agreement is the most comprehensive multilateral agreement on IP and the most effective instrument for ensuring that government takes steps to protect IP. I want to conclude this webinar with a recent statement by WIPO Director General Darren Tang. IP has been a powerful tool for supporting and encouraging innovation and has played a part in the fastest ever development of available vaccine, as well as the creation of technology that have allowed us to communicate, collaborate, and coordinate through the virtual means. This is why we believe IP continue to be part of the solution to our common global challenges. Thank you again, everyone, for your commitment, and I wish a wonderful World IP Day.